Good morning, everyone, and welcome to a new ForoCompetencia. Desayuno virtual ForoCompetencia virtual breakfast, and we have today a reason to celebrate. We have our 50th virtual breakfast, and we have a great speaker. We have Professor Eric Posner from the University of Chicago, who will be speaking to us about an issue that has grown significantly in the past years in the U.S. and definitely Professor Posner is a reference in this matter. So without further delays, Professor Posner, the floor is yours.
Thank you very much, and thank you for inviting me. I'm very pleased to be able to tell you about my work and this recent trend, not only in the United States, but actually throughout the world. And so what I call the new labor antitrust refers to antitrust or competition cases brought against employers, okay? Brought against firms for engaging in anti-competitive conduct against their workers, against their employees, okay? And this, of course, has not been the tradition of antitrust law, but it's a very much a growing development, and I will tell you about that in the course of my presentation today. But I want to start with this very famous, well, semi-famous case in the United States, and I think it's worth going through this just to give you a sense of why in the United States regulators have become very concerned about labor antitrust. Okay, so as you probably know, and I'm sure in most of your countries as well as the United States, antitrust cases against employers historically have been very rare. And when they have occurred, they've usually involved, relatively specialized circumstances. For example, in the United States, there have been a number of cases against sports teams or leagues, football, baseball, and so forth. And that's because leagues often have to disclose to the world the restraints that they use to prevent players from moving from one team to another. So to the extent there was much labor antitrust in the past in the United States, it was focused on this rather specialized area of the economy. So all of that changed in 2010. That's when the United States Department of Justice announced that it had both investigated and settled a labor antitrust case with a number of Silicon Valley tech firms. And this is often called the Silicon Valley no-poach conspiracy. And I just wanted to show you one piece of evidence. So this is from a slide that the government actually showed or prepared. This is an email chain between Steve Jobs, the CEO of Apple, and Eric Schmidt, the CEO of Google. So we're talking about the very top executives of two extremely important companies. And if you look at the bottom of the email chain, that was the earlier message. This is a message from Steve Jobs to Eric Schmidt, and it says, I am told that Google's new cell phone software group is relentlessly recruiting in our iPod group. If this is indeed true, can you put a stop to it? And then Eric Schmidt replies, I'm sorry to hear this. We have a policy of no recruiting of Apple employees. I will investigate immediately, exclamation point, Eric. All right, so what's happened here is that Jobs is angry because Google is hiring away Apple employees. And so he tells Google to put a stop to it. Okay. Now, this is clearly anti-competitive conduct in American law. In fact, it could very well be criminally prosecuted because it's what we call a naked horizontal agreement among firms not to compete in a market. What's unusual here is that it's an employment market or a labor market rather than a product market, okay? Now, this conspiracy did not involve just 2 companies. It involved 47 companies. And this, I don't know whether you probably can't read the names here. I'll read some of them for you. But if you look at the very center, I don't know whether you can see my cursor, but if you can look at the very center, that's Apple. Apple had no-poach agreements with Singular and Best Buy and Intuit and Microsoft, Genentech, a famous genetic technology company. Foxconn, J.Crew, which is a retailer of clothes, a company called Quanta, another company called Tech Data, Intel, the enormous manufacturer of chips, okay? And then Apple, if you can see in the lower left-hand corner, it had a no-poach agreement with Adobe, the maker of the PDF format. And Adobe, in turn, had no-poach agreements with another 7 companies. And if you look up at the top, toward the top, that's Google. And Google had no-poach agreements with Novell and Sun Microsystems and Oracle and Dell and Ogilvy. Ogilvy is an advertising company, okay? It's not even a tech company. DoubleClick, which Google would later acquire, Earthlink, and so on. And then on the bottom right, that's Pixar and Lucasfilm. They were involved as well, along with Walt Disney Company, DreamWorks, and Sony. So this was an enormous, wide-ranging conspiracy involving dozens of firms. The most important of these firms were the tech firms, Google, Microsoft, Apple, but it also involved firms that were outside of tech, advertising agencies, for example, eBay. And the agreement was basically focused on software programmers. Okay, so these companies were mainly worried that their competitors would hire away their skilled software programmers, their skilled employees. Although apparently it may have extended to personal chefs and administrative assistants of these companies, because often they would draft these agreements in very broad terms. 60,000 employees were affected over the period of this conspiracy. The origins of this conspiracy go back all the way to the 1980s, although most of the agreements were entered into in the first decade of the 21st century. And according to Matthew Gibson, an economist, as well as the expert in the case, the employees lost about $3 billion in wages. Okay, so it's a significant amount of money. These employees, this might surprise, I don't know whether this would surprise you, but their average compensation was around $100,000, $120,000. So this was a significant amount of money for most of them. If you're curious about this no-poach agreement, by the way, I have a recent paper posted on SSRN, from which this diagram is taken. The tech companies all settled the agreement. They settled with the Justice Department. They were subsequently sued, and they settled that private lawsuit for about $300 or $400 million. Okay, so keep that in the back of your mind. I believe that the Justice Department and the FTC were quite surprised to have uncovered this conspiracy, which I believe they learned about from a whistleblower. And so they would begin to develop some guidelines for labor antitrust that they would subsequently publish in 2016. It's called the Human Resources Guidance. And it basically says to firms, employers, by the way, antitrust law applies to labor markets, not just to product markets. But I want to switch gears for a minute and then talk about another development, which would later converge with these legal developments. And this is the economic research on labor markets. Okay, so I'm going to go through these next couple slides quickly. The basic thing I just want to convey to you is that this research is very, very important and very dramatic in its findings. and help change the way people think about labor markets. Indeed, a recent Nobel Prize winner has said, let me just say, basically, this big transformation in economic thinking. So traditionally, economists have assumed that labor markets are competitive. And what that means is basically that, I think they have in the mind a big city like Chicago or Buenos Aires or New York. And in those places, if you're a worker, you probably can go to work for a number of different employers because those cities are so dense. And so I think economists assumed that workers were generally benefited from competitive markets. But all of this changed in the teens as a result of additional sources of labor market data becoming available to economic researchers. So the first, one of the first papers, this one by Azar, Marinescu, Teinbaum, and Tasca, simply looked at labor markets around the country and measured their level of concentration, or HHI. And all that you need to know is that if you look at the map of the United States, it's divided into what are called commuting zones, which are basically areas in which workers are willing to look for jobs. So where they're willing to commute. And then they measure the number of employers that are available for any particular job specification. So for example, if you're a lawyer, you can go work for a law firm. If you're a doctor, you can work for a hospital. If you're unskilled, you may be able to work for a variety of firms, warehouses, fast food franchises, and so forth. The red counties, the red commuting zones have extremely high levels of concentration. Basically 1, 2, or 3 employers are available. The green have higher levels of competition. So it turns out that a huge portion of the United States, labor markets are actually very concentrated. And if you think about it, it's actually not that surprising. A lot of people live in small towns, rural areas, suburbs, and other thinly populated areas. There are a lot of people with highly specialized skills, like a neurosurgeon. And in all those settings, there are usually not that many employers who will hire you. So in those areas, there's a lot of concentration. The initial research has been confirmed again and again by subsequent researchers. Okay, second area of empirical research has involved mergers and acquisitions. And just summarizing this very roughly, if you, let me use the example from the third bullet point, hospital mergers. There are hospitals in the United States have merged a lot over the last 20 years. There have been a lot of mergers. Now, if 2 hospitals in New York merge, it's not going to affect the level of competition very much because there are a lot of hospitals in New York. But if 2 hospitals in, Springfield, Illinois, which is a small town, if they merge, then there may well be just 1 hospital, right? There may only be 2 hospitals in Springfield to begin with. Or if 3 hospitals exist and 2 of them merge, then there'll only be 2 hospitals. So Prager and Schmidt study mergers of hospitals around the country, and they find that when hospitals merge in the small towns and the concentrated labor markets, that results in lower wages for medical professionals, okay? So this is what you would predict. It's just like if 2 sellers merge, you expect higher prices if the market is already concentrated. Similarly, if 2 employers merge, you're going to expect lower wages. Okay, they have more market power, which they can use to push down wages. Oops. Okay, I will. Basically, this is just a table that shows the year relative to the merger and the acquisition, how wages go down, okay, in another paper by Arnold. And so you can see 4 years ahead of a merger, people are earning what is 0, meaning basically a competitive wage. and then after the merger, their wages predictably go down. Okay. Another area of empirical research involves collusion and coordination. There's been an enormous amount of empirical research on these topics, particularly the use of covenants not to compete. Covenants not to compete are agreements between employers and employees under which the employee agrees after he leaves the employer not to work for a competitor. Okay, so non-competes are controversial. In the United States, under the common law, courts scrutinize them and will strike them down if they're too broad. And this has been going on for centuries. But what people had never realized was just how common non-competes are. It turns out that as much as 20% of the US workforce is covered by a non-compete. And that involves all kinds of ordinary people, not just people with specialized skill. Another famous paper, this one by Kruger and Aschenfelter, discovered that all of the major, sorry, not all of them, about 60% of the major franchises in the United States, McDonald's, Burger King, Home Depot, and so forth, they use what are called no-poach agreements. So in the franchise form, usually the central company, let's call it corporate McDonald's, they have contracts or franchise agreements with multiple independent companies. And in those franchise agreements, the companies agree not to hire away workers from other franchisees. These are likely to be illegal. There's some controversy over that. But whether they're illegal or not, it's sort of amazing to think how many workers, probably 10 million workers or so, are covered by these franchise non-competes. And then there's also a lot of evidence of parallel and possibly collusive wage setting among lawyers and other professionals in the United States. You know, in addition to doing academic research, I also practice on the side. And so I do have this experience of a lot of people approaching me and talking about non-competes or even no-poach agreements that they're bound to. So they're very common anecdotally as well as in this more formal economic research. I'll skip this slide in the interest of time. Okay, and then the last section of empirical research I wanted to tell you about are countries that involve countries outside of the United States. Okay, so this research began in the United States, thanks to, as I mentioned, the release of a lot of valuable data about labor markets. But very quickly, many of these authors, who are often like not Americans, they go back and look at labor markets in their own country, and then foreign researchers have as well. And the sorts of things I've told you about, high concentration, numerous non-competes, have been discovered in multiple countries. France, Denmark, Germany, Italy, Portugal, Spain, and Brazil. Recent papers about Brazil. So wherever people have looked at the data, they have found a great deal of concentration in labor markets, okay? This is just a figure from one of the papers that shows the percentage of labor markets in various European countries that are either highly concentrated or moderately concentrated. And you can see this is a pretty substantial portion, ranging from 5% to 15% for highly concentrated. I do want to emphasize that not all labor markets are concentrated, not in the United States, not in other countries, but a very significant portion of them is. Okay, that's the empirical research. And now I want to just give you a brief refresher in the economics here. This will just be 2 slides. And I'm doing this because there is a misconception, a very serious misconception about the impact of anti-competitive behavior in labor markets on the economy as a whole. So there's a very common view that I've heard over and over again from practitioners and even sophisticated government officials that labor antitrust is not all that bad because after all, the employers are reducing their labor costs. And if they're reducing their labor costs, surely some of that savings are passed on to consumers who benefit, okay? So that's false. I want to make it clear, that's false. And let me explain very quickly why. Okay, so first, just to orient you, look at, firm one in the middle there. Let's imagine that's like your typical big company, okay? Let's say Walmart, for example. So Walmart both sells to consumers and it buys. Now it buys from all kinds of companies. It buys its stock from companies that make goods. But they also, of course, employ workers, hundreds of thousands of workers. Okay. So if Walmart is the only retail seller in, let's say, a town, we would call it a monopolist, right? That's familiar because there's just one seller. If Walmart is competing against just one other firm, let's say Target, then there's a duopoly, okay? And as competition or antitrust experts, we would be concerned about that. But Walmart also hires workers. And if Walmart is the only employer in a town, or one of a very few number of employers, then it has what's called monopsony power, which is just monopoly power directed on the other side of the market, to the input market. And my particular focus is labor monopsony. All right, so we're talking about think of small towns, rural areas, suburban areas, where you have a few very big employers. You have some fringe employers like coffee shops that employ very few people. But basically, people don't have much choice where to work, right? So in the United States, this is very common. There are small towns, for example, that might have a couple huge warehouses operated by Amazon, and that's the main source of employment. And then maybe it has some fast food franchises and maybe an automobile repair shop. So if there's one automobile repair shop, there's only one employer for mechanics. And if there's, a huge Amazon warehouse, that's where less skilled people might have to go. Okay. So I'd like you to just briefly look at these two graphs. The one on the left, which is, by the way, taken from Wikipedia, is your standard depiction of monopoly. And everybody knows that if a firm has monopoly power, it's going to raise prices from PC to PM, so from the competitive price to the monopoly price. And that results in a reduction in quantity, okay, from QC to QM. Okay, so output goes down, and then we get this deadweight loss, which is the yellow triangle, right? So everybody understands there are a number of consumers out there who value the good more than the cost of producing the good. In an efficient market, they would be able to obtain that good. But because the seller is a monopolist, it wants to gain more of the surplus from the consumers who value the good more. So they raise the price, and that drives some of the consumers out of the market, right? Standard thinking. Now, on the right, this is the standard graphical depiction of monopsony. All right, so monopsony is just the mirror image of monopoly. Now what happens is you've got, so first think of the competitive firm, that's W prime here. They set the wage where marginal revenue product equals marginal cost. And that results in, that results in a relatively high wage. That's W prime, okay? So in other words, the way this is working is you're an employer and you want to hire somebody, but you have a lot of competitors who are trying to hire the same person. So you're going to have to keep raising the wage until that person will come to you. And ultimately, you raise the wage so that it equals, in equilibrium, the benefit that the worker is giving to you in the form of increased production or productivity. Now, if you're the only employer, what you do is you push down the wage, right? You push down the wage, you save on labor costs, right? That's very rational. But the only thing I want you to look at is what happens to the amount of labor. It goes down from L prime to L. right? And this is very logical. If you push down the wages, fewer people are going to work for you. And well, what happens to those people? They might retire early. They might become unemployed. They might go work in another labor market where their skills are not as valued. That's an economic loss. And in fact, under a simple setup, if you have a firm, if you have, let's say, a small town with a bunch of competing retailers, and they all merge into a single Walmart, employment goes down, not up, which means that there'll be fewer sales, which means the consumers in the town will have less choice, and indeed that prices will go up. Okay, so basically, like antitrust law, competition law is based on the theory that competitive markets are good. They maximize output. Okay, and they also maximize consumer and worker surplus. And so if employers engage in anti-competitive behavior, you get the same result as if sellers engage in anti-competitive behavior. Lower output, right? And that's a bad thing. Okay. And this is this graph is based on some work done by some economists, and it just shows this is just an example of like your average town. If HHI, if it's a very competitive labor market for, I think this is for like an administrative assistant in a small town in the Midwest, the salary is around $45,000 a year. And as you increase toward a pure monopsony, a single employer, it falls toward $30,000. So that's a third of the salary disappears. And some people are going to quit if they're not paid that much. There's also an estimate that in the United States, labor market, the current degree of labor market power results in output losses of somewhere between 5 and 20%. Okay, let me turn to the law now. Antitrust law at a high level of generality is not very complicated. There are basically three types of anti-competitive behavior that the government focuses on and the plaintiffs bring cases based on. First of all, there's Sherman Section 2, which just says maintaining or obtaining a monopoly is illegal or may be illegal. So in the case of labor markets, we would talk about obtaining or maintaining a labor monopsony. So for example, if a single employer engages in anti-competitive conduct in order to prevent other employers from entering into the market, that could be a Section 2 violation. Then there's Section 1, which is just contractual methods for expanding labor market power. So on the seller side, we think of price fixing agreements. On the employer side, we think of wage fixing agreements. On the employer side, we worry about, on the seller side, we worry about sellers sharing information, pricing information. On the employer side, we worry about employers sharing information about how much they pay their employees. And then there are these no poach agreements. Now, the analogy on the product market side would be an agreement between two sellers not to poach each other's customers. No poach agreements seem to be common in labor markets. That's the Silicon Valley Agreement. This is where employers agree not to hire away or poach each other's employees. And then finally, there's the Clayton Act Section 7, which prohibits mergers and acquisitions that may substantially lessen competition. So mergers can reduce competition for workers, just as they can reduce competition for consumers. Now, historically, as I mentioned before, antitrust law is oriented toward the product market side or the seller side. And this is just a graph that shows, this graph is a few years out of date, but it shows that over 3 years, there were 160 or so Section 1, Section 2, and Section 7 cases involving the product market side, the traditional type of antitrust. And what the orange bar shows are the labor market cases. And as you can see, they're much less common, although this is changing. Okay, and I'll talk a little bit more about the recent cases in a moment. One interesting question is, why has there been this historical lack of antitrust enforcement in labor markets compared to product markets. In the interest of time, I'll just tell you, two possibilities. One is that traditionally unions have protected employees. That began to change in the United States in the 1950s. Today, unions control only about 6% of the private labor force. Unions in the United States have been hostile to antitrust law because at its inception, antitrust law was used to break up unions. So there may be this kind of historical memory. But I also think a big part of this story is just this traditional assumption that labor markets are competitive. So there's no particular reason for plaintiffs or government regulators to look for anti-competitive behavior in labor markets. This gap in litigation is beginning to narrow. So what I have here are some statements from the late teens. Now, what's interesting here from a political standpoint is that this concern about labor antitrust, so it actually begins in the Obama administration. That's when this human resource guidance was issued. But it continues during the Trump administration. And, people tend not to think of Trump as, not particularly sympathetic to workers. And yet the Trump administration, DOJ, Department of Justice, began investigating and began prosecuting employers for no-poach agreements and other anti-competitive behavior in labor markets. Now, during the Biden administration, this accelerated. And in 2023, the Biden administration issued the revised merger guidelines, which have a new section on mergers that cause harm to labor markets. And incidentally, I was at the Department of Justice on a detail, and I helped them, develop their labor antitrust enforcement policies, including the merger guidelines. And now, again, in the new Trump administration, both the FTC and the DOJ have issued very strong statements affirming that they are going to spend resources enforcing antitrust law against employers. So this is no longer a kind of a niche area of antitrust law. It's central to antitrust law in the United States. So a brief description of some of the litigation that has occurred in recent years. So as I mentioned, the Justice Department began to actually criminally prosecute executives who had entered into no-poach agreements. As I'm sure you know, in the United States, people can be held criminally liable for antitrust violations. Now, most of these investigations resulted in trials that resulted in acquittal, but just earlier this year, there was the first conviction of somebody, okay? And so basically what this was it was like a small, I think, healthcare-related firm. The executive had entered into agreements with competing employers not to hire away each other's employees. And the government got wind of this and prosecuted him, and now he faces a jail term. There have also been several merger challenges. Some of these have been, the FTC filing documents in related cases. But I think the most significant such example is the Justice Department's enforcement action against a merger between Penguin Random House and Simon & Schuster. So those are the first and third largest commercial publishers in the United States. And what was very important about this merger challenge was that it was based on the labor market effects of the merger, not the product market effects. In other words, the DOJ said this merger should be blocked because it will result in lower compensation to authors. And they made no argument about whether the merger would raise the prices of books. And I'm going to go into a little bit of detail about this merger in a moment. And then more recently, the FTC challenged the Kroger-Albertsons merger. Those are two big grocery chains. and merger between Tapestry and Capri. Those are luxury goods manufacturers. And in both of those cases, the FTC emphasized the labor market effects of those mergers. I should mention, by the way, that all of these challenges were successful and the merger was blocked by the courts. There's been a lot of Section 1 litigation. So those franchise no poach cases have resulted in lots and lots of, those franchise no poach agreements have resulted in a lot of cases. They're still kind of working their way through the court system, but basically all of the franchises have agreed to drop the no poach clauses in their franchise contracts after they were sued by a state attorney general. There's been a lot of litigation about, poultry workers and staffing agencies. And then there's been a huge amount of litigation against sports leagues. Above all, the NCAA. This is the National Collegiate Athletic Association, which manages, college football and college basketball in the United States. These are enormous parts, entertainment franchises. And there's been a recent settlement. It hasn't been finally approved between the NCAA and a class of employees. And that settlement is for close to $3 billion. Now, this is an extreme case because the NCAA had actually said to the colleges, you're not allowed to pay student athletes, even though they seem a lot like workers. Okay. And this has been going on for decades. So the court said, no, I think you have to pay. You can't agree not to pay your workers. And so you bring in an economist to estimate what they would have been paid in a competitive market. And the settlement was, as I mentioned, $3 billion. There's also been Section 2 litigation. And so there's another case which settled recently called Lee versus Zuffa. And this was a case brought by mixed martial arts fighters against the promoter. Okay, so this is in the last 20 years or so, mixed martial art fights have become popular in the United States. They're televised. The fighters are often, famous. They have a lot of fans. And the plaintiffs were a class of mixed martial arts fighters who sued the promoter because the promoter engaged in various anti-competitive acts, basically imposing very extreme contract terms that made it difficult for the fighters to go work for another promoter. They settled for, I think, around $300 million. Okay, another big case. And then, as I mentioned, the merger guidelines were revised. So these cases, they're just multiplying, okay? There are many, and I'm actually involved in a number of them going on today. Okay, I think I should stop speaking in a few minutes, but let me just give you a kind of a more detail about one of these cases. So this is the Penguin Random House Simon & Schuster merger, which the government challenged. So in a classic classically, if two publishers merged and the government challenged the merger, it would say to the court, look, this merger is going to result in higher prices for people who buy books, so you should block it. But what happened in this case was that the government said this merger will result in lower prices, lower wages, lower compensation for the authors. So you should block it, okay? And so, but basically the usual analysis is used. So first of all, so these images are taken from exhibits in the trial. First of all, the government defined the market as top-selling authors. Those are authors who receive advances of over $250,000 for a book. Government accepted that market definition. If you have questions, I can talk about why. Once that market definition is accepted, the HHIs can be calculated. And as you can see, the post-merger HHI would be over 3,000. The delta is over 800. So we have a prima facie case that the merger will substantially lessen competition. Okay, if you look at the left, that's Penguin Random House, which has 37% of the market, and Simon & Schuster that has 12%. They're basically 5 big firms. Now, there are all kinds of interesting aspects to this case, including the unilateral effects analysis. So basically, what the government's expert told the court was that when authors are selling their book manuscripts to publishers, an auction is held among the publishers. And what the expert showed was that the auction usually involved competition between Penguin Random House and Simon & Schuster for a particular author. Like they bid up the advance for the author. And so if the 2 firms merged, to use this example, the auction would have ended at around probably $650,000 rather than at $825,000. The expert also talked about diversion ratios. And you can apply diversion ratios to labor markets just as you can to product markets. What they showed from the auction data was that even when Simon & Schuster wins an auction, the author's next best option is Penguin Random House. So that means that if the 2 firms merge, the compensation for authors will decline. Okay, and then there are similar sorts of unilateral effects analysis and so on. I won't go into details here. If anybody wants these slides, I'd be happy to send them to you. Just email me. But similar analysis results in statistical evidence that the merger would reduce compensation for authors. There's also a coordinated effects analysis. And one probably important fact for the court was that there was actually a history of coordination among the publishers. So it didn't seem surprising that they would also coordinate after the merger, and that the coordination would have even more effect. Okay, my last point is I think there's still a tendency for people in antitrust circles in the United States to think that, labor markets aren't that important. I don't think so. I want to, I think that's just kind of a prejudice. Is we're used to talking about product markets in competition law and antitrust law, but labor markets are just as important as product markets. It's the workers who make the goods, and most people, are workers as well as consumers. So if you're like all of us, we're working and getting paid, and then we're using that money to buy goods. We should be indifferent as between whether, we lose money as a result of our employer engaging in anti-competitive conduct or the people we buy products from engaging in anti-competitive conduct, right? Just, we're hurt. But there's a sense in which work is more important for people than consumption. Of course, consumption is vital. You need to buy food and shelter and the good things of life, but people spend, most of their waking time working. And the quality of their work and the compensation, these are all things that are very important for people's self-esteem, dignity, happiness. Okay, so I do want to emphasize that, in my view, there should be much more concern about labor antitrust than about traditional product market antitrust. And what this means is that, let's say, just for purposes of this discussion, antitrust enforcers in the government should devote more resources to investigate labor markets. I want to conclude with a famous quotation from Adam Smith, which I think, he was a wise man, and this is an amazing quotation. I'll read it to you. He says, "We rarely hear, it has been said, of the combinations of masters," that means employers, "though frequently of those of workers." And so he's talking about, people forming unions. But then he continues, "But whoever imagines upon this account that masters rarely combine is as ignorant of the world as of the subject. Masters," again, employers, "are always and everywhere in a sort of tacit but constant and uniform combination, not to raise the wages of labor above their actual rate," right? So employers, they're always like dealing with each other. They're always talking with each other. And so there are all of these opportunities for them to say, hey, let's not steal away each other's employees. Like, we'll have to pay them more. That's bad for both of us. And so this is, I think this was true in 1776, and it's true now. And so for that reason, we should be more concerned about anti-competitive behavior in labor markets. So thank you for listening, and I'd be happy to take any questions.
Great, thanks. In fact, there are already 3 questions in the chat. I don't know, Carlos Casañas made the first question. I don't know if you want to do it in person. Carlos comes from Paraguay. Carlos, you're on mute. Carlos, you're on mute.
Okay, ahora sí. Okay, good morning. Some years ago, a general discussion started in Paraguay because some people who work in public positions or in public companies were hired by private companies related to the field they have been working after they leave public positions, and so they carried to said private companies informations and knowledges that they acquired in said public positions that, of course, in many cases were sensitive and or strategic. So in view of this, a revolving door policy law was enacted, stating that people cannot be hired for private positions similar to the public ones they were previously, well, for a couple of years. Okay, this is a prohibition, a ban for a couple of years. So, Professor, what is your opinion about this? Do you think said measure is really justified? Are there other options more appropriate in terms of competition?
Right, so that's a very interesting question. I do think that a law like that is justified. You don't want to make it too strong, but the revolving door is a big problem in the United States as well. So I worked in the Justice Department, and when I left, I was put under a kind of ethical obligation not to do any work for clients who had business in front of the Justice Department while I was there. Now, that's obviously extremely reasonable, and I think that law is sensible. The only concern I would express is that if people know that when they're considering employment by the government, that they won't be able to go into the private sector, or their opportunities to go in the private sector are limited after they leave the government, they may not join the government in the first place. So one has to balance these two competing considerations.
Thank you.
Right, now to the United States, Alden Abbott.
I'm sorry?
Oh, thank you, Eric. You didn't comment specifically on this issue of non-competes, and of course, I think at this stage the outlook for the Federal Trade Commission's rule banning most non-competes is dim. But one, obviously, hardcore, say no poach agreements, that maybe seem close to per se illegal activity. What about non-competes? Do you think a special rule of reason framework needs to be developed to look at those? Because certainly for high skilled employees and employees in areas where there are no specialized know-how and specialized investment in human capital, you might see some benefits to limited non-competes.
Yes, I agree with you. So there is a good theoretical argument that non-competes are beneficial under certain circumstances. And as you mentioned, they're beneficial, for example, if the employees have access to proprietary information, if they've been trained in the employer's if the employer has trained them so that they develop skills that are valuable to competitors. And the common law in the United States has always taken the view that non-competes are sometimes justified and sometimes not. So in the United States, and I believe this is similar in other countries, a non-compete will generally be enforced if it does involve a highly skilled worker or somebody with access to proprietary information, and also if it's narrow, meaning that the person in question may be able to find a job, let's say, in another part of the country, or that the non-compete's duration is not too long. So 6 months might be okay, but 3 years would be too long. Now, I think that's sensible in theory, but what has happened in practice in the United States is that employers have imposed non-competes on millions of workers who don't actually satisfy those criteria. And so I believe the rationale for the original FTC rule banning non-competes was that, sure, they might make sense in certain circumstances, but in light of their overuse, we should just get rid of them altogether. Now, that was a controversial position. In the end, I agreed based on the empirical evidence, which did seem to indicate that where non-competes are used, workers are hurt and there's relatively little benefit. That said, I agree with you. It's unlikely that the rule will be upheld by the courts. And so the question now becomes is how to think about non-competes from the standpoint of antitrust law. Interestingly, Andrew Ferguson, the head of the FTC, has said that even though he doesn't support the rule, he does want to bring enforcement actions against employers who use non-competes, I suppose, in anti-competitive ways or excessively anti-competitive ways. I think your question raises a good topic for further research. Is there a way that we could modify antitrust law to make it easier to block significantly anti-competitive non-competes while permitting those that are competitive or beneficial? I have given some thought to this, but I don't think there's an easy answer to this question.
Thanks. Now we go
Thank
to
you.
Brazil. Now we go to Brazil. We have 2 questions from Brazil, Rodrigo and then Ricardo. Rodrigo. Oh, he said, Professor, is it possible that a workers' union created by companies to reduce workers' rights could harm competition?
Yes, I think it is. There's actually a history in the United States of employers creating creating unions. Those were called company unions. And I believe that the general view is that the purpose of those of doing that was not to help the workers, but to deter them from forming their own independent union that could challenge the employer. So company unions are actually illegal in the United States for just that reason.
Thanks. Ricardo.
Well, first of all, thank you very much for the presentation. Professor Posner is obviously one of the highest professors that have been part of ForoCompetencia. Thank you, Julian Peña, for organizing it. I first would like to say that from my perspective, I believe that there are some subjects from labor perspective that also may call the attention from the antitrust authorities. But I have 2 doubts to ask to Professor Posner. The first one is how the labor market would fit the concept of relevant market from an antitrust perspective, in terms of geographical perspective and product perspective. And the second one, I was hearing Professor Posner saying about, well, the possible violations from merger cases. And then I understood, maybe I misunderstood it, but I understood that the result of a merger that could reduce the conditions of the labor conditions could be considered a antitrust violations, at least from the US perspective. But from the other side, we always hear from merger control decisions and merger controls cases that one of the possible efficiencies is to reduce the duplication of employment positions in terms of one of the possible efficiencies resulting from the merger. How would Professor Posner differ the two perspectives of the same coin? There's two
Right.
sides of the same coin. Thank you, Professor,
Yeah.
again.
Right. So very good questions. So for labor market definition, it's very similar to what we do for product market definition. We just have to kind of look through the mirror and think about input markets rather than output markets. And, actual input market cases are not uncommon. So for example, if you have, let's say Walmart buys goods from suppliers, that we use a product market definition. We look at whether the goods are substitutes and that sort of thing. So what workers do is they provide services. And sometimes these services are kind of complicated. Like you can imagine a CEO, what runs the company. And sometimes they're very discrete though. So for example, a worker might be an electrician who repairs defects in electrical wiring in a factory. Now, in that case, there are two elements to the market definition which parallel the two elements to product market definition. You look at geographic scope and you look at the nature of the work. So in the case of geographic scope, the general view is that you should look at how far people are willing to commute to work, right? And that parallels what we do with product markets. So if we're trying to understand whether a grocery store merger, a merger between two grocery stores is anti-competitive, we have to ask, how far do consumers travel in order to shop for groceries? They might drive a few miles, they're not going to drive, 20 miles or 50 miles. Similarly, if we're looking at the grocery store workers, we have to look at how far people are willing to commute to work at a grocery store. If the two grocery stores that are merging are very far away from each other, the merger might have no impact on labor markets because people may only be willing to work at a grocery store if they can walk there or take the subway or a bus, and it's very close. So economists are needed. They're rough ways of doing this, but basically, ideally, an economist would be used to look at data of commuting patterns, how far people travel when they commute. Okay, so that's how you determine the geographic scope of a labor market. For the definition of the occupation, so a starting point is that the government the U.S. government, and I'm sure all governments have kind of a listing of different occupations. And they're assigned numbers. And so you could be a car mechanic, that's one occupation, be a lawyer is another occupation. Now, again, the government definitions are just a crude starting point. And what you really need is, again, economics to look at the substitutability across different types of occupations. So, for example, if I'm a neurologist, like a doctor who operates on people's brains, my only substitute would be a number of hospitals, probably very sophisticated hospitals, that are willing to hire me. By contrast, if I'm unskilled, I may be able to work for fast food franchises, warehouses, factories, and in that setting, all those employers would be part of the labor market. So it's a fact-specific inquiry, but it is no more, at least conceptually, it's no more difficult than defining product markets. You also asked about the efficiency side. So basically, if a firm reduces its labor force as a result of a merger, there could be two reasons why it's doing it. The first is an efficiency reason. In other words, there's redundancies, and that we actually, if we have fewer workers, they'll be more productive, which actually would mean that their wages would increase. Because in a competitive market, the more productive you are, the higher your wages. Okay, So, and then the other possibility is that the reason why the merged firm will fire workers is that it obtains market power that allows it to just lower wages, which will effectively cause merger workers to leave voluntarily. Okay, so that's another of this kind of economic inquiry that has to be made. It's exactly parallel to what we do on the product market side as well.
Thanks. Now to Argentina, Esteban.
Thank you.
Windows.
Thank you. A very insightful presentation. Thank you, Professor. My questions were very similar to Ricardo's one. Maybe about how, if you can make an example about a case where these issues were discussed, the market definition and efficiency defense.
Yeah, well, certainly I highly recommend the case, the Penguin Random House Simon & Schuster case. So that's a published case, it's online, and the judge talks in great some detail about product market definition. For efficiencies, an interesting case for you to read, I'll type it. It's called Desayuno versus McDonald's. It's Seventh Circuit, Judge Easterbrook. And this involves the McDonald's franchise. And he talks a little bit about this sort of efficiencies aspect of things. But the truth is, there just have not been that many cases. So it'll be a while yet before we see how courts address these types of problems. Generally speaking, in merger cases in the United States, the efficiencies defense almost always loses. So so there's usually not that much information.
But maybe there can be some kind of arguments. I don't know if in the case law we have this kind of situation where the companies need to gain scale because they compete globally or maybe national, but they consolidate in a location where they are the main employer of this local city or town. Maybe how to combine these two effects, demand side and supply side, is something that we need to think about it.
Right. So in U.S. law, there's a doctrine that says that if a merger causes harm in one market, it's illegal, even if it causes benefits in another market, right? So traditionally, this is used just on product markets. If two grocery store chains merge, they're actually affecting lots of different product markets. And if, most of the product markets are benefited, prices go down, but a few are hurt, prices go up, the merger is prohibited unless the merging firm divests, the grocery stores and the more concentrated markets. Now, this type of cross-market balancing arises again when we start looking at labor markets. From a legal point of view, if a merger benefits consumers but harms workers, it will be illegal, just as a merger that benefited workers and harmed consumers would be illegal. Now, you could say that's not a good doctrine, and economists certainly and policymakers can debate whether courts should try to balance benefits and costs across markets. If you did that, an economist could do it or could tell you that they could do it. Like there are ways of like comparing how much consumer surplus is generated and how much worker surplus is harmed. So that would be, that would certainly be a possible way to design the system of review. But because this is actually what Judge Easterbrook talks about in Desayuno versus McDonald's, because our law is not like that, this issue has not come up.
Thank you. Thank you very much.
We now go to Uruguay. Jonathan.
Yes, sorry. No, I think you mentioned it, and maybe you were going very fast, or I was being very slow. But I just didn't understand fully the point. Is do you think that the deadweight loss you were showing in the diagram about labor markets is partly a consumer welfare standard issue, or like part of this is recognizable as harm under the consumer welfare standard, or is it always going to be aggregate welfare standard? And do you think it matters when we're looking at antitrust in labor markets?
Okay,
Thanks.
great. Let's just think about like the traditional way in the United States of evaluating mergers, which would be that you would look only at consumer welfare effect and nothing else. So if a merger increases consumer surplus, it's okay. If it reduces consumer surplus, it's bad. Like that's the tradition. So now we start focusing on mergers that affect labor markets. And the parallel type of inquiry would say, let's just look at the workers' surplus, the producer's surplus. If the merger causes the workers' surplus to increase, it's okay. If it causes the workers' surplus to decline, it's illegal. How could it cause the workers' surplus to increase? Because the merger results in efficiencies that make the workers more productive. And then the firm, because it doesn't have excessive market power, labor market power after the merger, has to pay the workers more, okay? Or else they'll lose them to other employers. That would be exactly the same analysis that we currently do, except on labor markets. Okay, so you might look just at the consumer surplus triangle when mergers hurt when mergers are kind of oriented toward consumers but not workers. Just the workers surplus when their main effect is on the labor markets. Now, what happens if a merger has an impact both on labor markets and product markets? So one point I was trying to make was that usually, like in the very simple economic models, if a merger has a negative impact on labor markets, it will also have a negative impact on product markets. And the reason is the negative impact on labor markets means that there are fewer workers, and the result is there's less output, right? And if there's less output, that means prices will go up on the consumer side, right? And similarly, people rarely have thought about this, but if you have a merger that hurts consumers, well, what does that mean? It means that the merged firm is going to raise prices. That means that fewer consumers will buy goods, which means that output goes down. But if output goes down, the firm needs fewer workers. So the workers will be hurt as well. So you can imagine, saying it doesn't really matter whether we have a consumer welfare standard or a worker welfare standard or an aggregate welfare standard, we'll get the same results, right? And so we don't need to change anything. Now, there are two problems. One problem is just a problem of evidence. Sometimes it's easier to understand the impact of a merger on one market than the other. So I think what was happening in the Penguin Random House case is that the Justice Department believed that it would be able to prove that authors would be hurt, but wasn't so sure that it could prove that consumers would be hurt. Because, consumers have lots of substitutes. If the price of books go up, they can watch videos. Whereas authors, people who write bestsellers, they may not have substitutes. Like if the price that they're paid for writing a book goes down, it's not clear what they do now. So there are these evidentiary differences as well. And then to get back to the earlier question, there is this concern that if you actually aggregate, like you look at total welfare, it's just too complicated to do. It's just because the problem becomes way too complicated. So my view is that when you have a merger, the regulatory agency, should select the market that it thinks is most clearly harmed and bring that to the court. And if it's the labor market and the agency can show that the labor market is harmed, the merger should be blocked. If it's product market and the agency shows that the product market will be harmed, consumers will be harmed, the merger should also be blocked.
Thank you.
Back to Brazil, Fabiana.
Hello. Thank you, Professor Posner, for your presentation. It was a pleasure, true pleasure, hearing from you after reading so much of your work. I have a question regarding the debate of workers' classification or collective bargaining mechanisms, and in the Simon Schuster and Penguin case, because we could argue maybe that this case is not properly a formal workers case, employed workers. Maybe the writers could be considered as freelancers since they did the bidding scheme and for the payment of the books. So I believe this was not an aspect which influenced the court's decision. And my question is, should this debate influence the merger review cases regarding worker antitrust, or it only has implication in the collusions in the conducts case? I'm very curious because this case is the first workers harm theory merger case, but they are not formal employed workers.
Yes. So that's a good question. So first, I just want to mention that in the Kroger-Albertsons case, these were regular employees, grocery store employees. And the FTC argued that the merger would hurt the grocery store employees. The case was actually resolved without the court reaching that issue, but it actually, there's a state that's, I think Washington State or Oregon has also brought this case, so we might see an actual merger case involving employees in the legal sense rather than independent contractors. So as you point out, the authors in the Penguin Random House case would probably be regarded as independent contractors under U.S. law and the law of other countries rather than employees. But from an economic perspective, let's move from law to economics. From an economic perspective, they're workers, So if I write for a living, let's say I'm an author. I could, sometimes I sell my books or articles freelance, or I could go start working for a magazine or a newspaper or even a corporation doing technical writing. And so the same set of skills will be used by some people as independent contractors and other people as workers or as employees, I should say. And this, of course, is very common. Think of plumbers and electricians and carpenters. Some of them go and work for companies and become employees. Others hold themselves out as businesses, and they find consumers who hire them. I don't think from an economic perspective there's any reason to distinguish these groups. Employees tend to be a little bit more vulnerable because they are dependent on a single entity for their livelihood, whereas independent contractors are more independent. If one person fires them from a plumbing job, they're more likely to find other people to hire them. But ultimately, that's an empirical question. And in the Penguin Random House case, the court actually thought that even though the authors were independent contractors, they would be harmed. And I think the significance of the case is not so much, whether these authors were independent contractors or employees. It was that they were just like ordinary people rather than firms who were selling their skills rather than buying goods and services.
Thank you so much.
Now to Colombia with Daniela.
Thank you, Julian, and thank you, Professor Posner. I had a question that will maybe take you to a hypothetical world, but I was wondering, in a merger control scenario, could you imagine any specific type of remedies that could be acceptable to approve a transaction that, on a first hand, seems to create at least danger for the labor market, but that could be useful to get the clearance?
Well, I mean, I could think of possibilities. I don't know how realistic these are, but for example, if the workforce is unionized, the employer might, make an agreement with the union not to lower the wages of the employees, a contractual agreement, or it could maybe make an agreement with the government not to lower the wages of employees after the merger. There could be a divestment remedy. So, for example, in the Kroger-Albertsons case, the merging parties offered to sell grocery stores that they owned in concentrated markets to a third company, right? So that's a standard kind of remedy in merger cases. So those would be the two, I think, the two most plausible remedies that I can think of.
Thank you.
Great. Thank you very much, Professor Posner, for your generosity in time and in knowledge. Now we have a tradition that you have the speaker has time for concluding remarks. If you want to add something.
Sure. I mean, I hope that I know there are people here from many different countries, and I hope that the people will start or continue debates about the relationship between labor markets and competition law. I believe I don't have a great deal of knowledge about competition law in foreign countries, but I believe that as a general matter, there is no restriction on using competition law to address problems in labor markets. So I'd love to see this type of litigation occurring elsewhere in the world. So thank you very much for your time. I really appreciate it. And if you have any questions, feel free to email me. I'll type my email address right here. And I can answer your questions, and I can also point you to articles or cases if you're curious about reading more.
Great. Thank you very, very much. And I'll see everyone next month. We have Professor Ioannis Ilianos as a guest speaker next month. So I look forward to seeing you then. Thank you, Professor Posner.
Thank you. Bye.
Thank you.
Bye-bye.
Bye.
Don Julián Peña.
Profesor, ¿todo bien?
Todo bien, todo bien. Lindo el desayuno, ¿eh? Felicitaciones.
Gracias, estuvo muy bueno. Además,
Bueno.
quedó reflejado por la cantidad de preguntas que han habido.
Y sí, y sí.
Así que bueno. Te mando un
Bueno,
abrazo.
hablamos.
Parabéns,
Chao.
Julián.
Obrigado.
Maravilhoso.
Chao, Mariana.
Tchau, tchau.